how do you appeal it? What areas of this can Deshaun Watson and his team appeal? Because it sounds like, it's not going to be outstepping the bounds because they collectively bargained that, Roger Goodell or his designee would have the right to appeal. What area of this can be challenged by the NFLPA?
Well, it's not going to be the weight of the evidence because federal courts are not going to reweigh the evidence or decide that they would have decided the case differently. Judge Sue Robinson has already identified the issue that will get the Players Association and Deshaun Watson into federal court. I think it's on page 13 of her opinion, the issue of fair notice. Now, she wrote that when there was all this public outcry in the aftermath of the Ray Rice initial suspension of just 2 games, the league revised its personal conduct policy to create a minimum suspension of 6 games whenever there was violent conduct involved. So what Sue Robinson wrote in her opinion is that, that provided fair notice to the NFL players that they would be subject to a minimum suspension of 6 games if their violation of the personal conduct policy involved a crime of violence or any kind of violent conduct, which is the use of physical force. By contrast, in this situation, it's undisputed by the NFL and by the Players Association that this was not an offense involving violent conduct, the use of force. And she wrote that the players in this instance, unlike the Ray Rice scenario where you knew you're going to get dinged for at least 6 games if the conduct involved violence, she wrote here that the players didn't get fair notice, that nonviolent conduct would be treated as severely or more severely than violent conduct. Because remember, the minimum suspension for violent conduct is 6 games, and the league is asking asked Sue Robinson to impose a 1-year suspension based on a nonviolent violation or nonviolent offense of the personal conduct policy. And that implicates the due process clause of the U.S. Constitution, because due process applies not only when the state tries to prosecute you, it applies equally to administrative proceedings and arbitral proceedings. And under due process, a person has to have fair notice, not only of the conduct that will subject him to punishment, but also of the severity of the penalty that the state or the agency may impose. And while Deshaun Watson had noticed that the conduct would subject him to punishment, he never received any notice, nor did any of the NFL players receive notice of the penalty that would attach to a violation of the personal conduct where nonviolent conduct was involved. And that's his winning argument in federal court. Now, if I'm Jeffrey Kessler, I focus. We don't have an appellate decision yet, so I don't want to foreclose other possible arguments. Maybe there's a bias or an evident partiality argument based on the identity of the arbitrator. I don't think that's a winning argument, but I think the due process issue and the issue of the lack of fair notice, which Sue Robinson identified in her decision, that's going to carry forward to federal court and could resonate with a federal court judge, because while there's a very limited standard of review or very limited inquiry that a federal court would make in a labor arbitration award, there are very limited circumstances. You look to whether the arbitrator construed the agreement, not whether he got it right or wrong, but only whether he construed the essence of the agreement. But there are exceptions. And one of the exceptions is manifest disregard of the law and violation of public policy. And one could argue that ignoring the constitutional cornerstone of the due process requirement of fair notice is not just a violation of the law, but it is a manifest violation of the law that would constitute not only that exception to judicial, favoritism of an arbitration award, but would it also implicate the public policy exception to judicial confirmation of labor arbitration awards. So I think there are 2 avenues that Watson and the NFLPA can pursue: manifest disregard of the law and the public policy violation that is anchored to the lack of fair notice, which is a due process consideration. He never got fair notice of the severity of the punishment that he would be subjected to, not where the league is trying to punish a nonviolent offense twice as severe as a violent offense. And I think that's where he has a sliver of hope in federal court.